So some other techniques, not being a passive judge, so actively seeking information in order to reach a just decision, actively asking about, for example, in criminal sentencing, asking about the defendant's circumstances rather than just relying on the information that comes to the court. Managing the courtroom in a way that protects vulnerable parties, making sure that people who are outsiders who might be feeling uncomfortable or alienated, that the process is explained to them, that they know what's going on, that having the judge directly interacting with parties rather than only sort of talking to their lawyers, demonstrating empathy and compassion for people's life circumstances. And then when we're getting into the actual decisions that are made, making perhaps more creative dispositions and remedies. So some of the feminist judgments have involved, and some of the other judgments have involved thinking, well, there's not much that we can do in terms of providing the remedy that the person might want, but we can provide some guidelines for what should happen in future cases, or in a couple of cases, making an apology on behalf of the court or on behalf of the justice system for historical injustices that have occurred and that, that can't be adequately remedied in other ways. Writing judgments in a ways that shows that the participants have been heard, treating them respectfully, directly addressing, for example, in sentencing cases, directly addressing the family of the victim and referring to their victim impact statement and, saying that the judge understands how they feel and how traumatic this whole experience has been for them. Communicating judgments in different ways. So there's been some interesting work done in the sort of children's rights context in particular. They're actually writing judgments for children. So producing judgments so the child is the subject of the case. How do we then communicate the outcome to that child, and writing the judgment in a way that will be understood by the child. Recognising legal pluralism has come up particularly in some of the sort of Indigenous judgment projects of being conscious of sort of bringing in the Indigenous worldview and the notion, some sort of Indigenous concepts and legal concepts in crafting appropriate resolutions or appropriate understandings of the case. And then, some of the sort of more far out, so one of the projects is the Wild Law Judgments Project, which is a sort of environmental law, which went so far as to give legal personality and legal standing to non-human entities such as creatures and trees and mountains and rivers and so on, which is a really inclusive beyond the sort of individual humans into a non-human entity. So that's really sort of taking inclusivity to really new levels. So, but I suppose one of the things that these projects has demonstrated also that there are limitations to what can be done within the scope of mainstream court processes. So first of all, little opportunity to be inclusive if you're not dealing with cases that raise those kind of issues. Fact that sometimes the judge can't introduce things of their own motion. They need a lawyer to make the argument before they can actually respond to it. Sometimes the judge has no role. For example, in common law criminal trials, the judge doesn't make any decisions. They can only direct the jury. And so they have limited capacity to, affect the outcome. Sometimes the judge is simply bound by legislation and precedents and can't reach the result that they want. There might be procedural rules limiting access and effective participation, particularly when children are the subject of proceedings but are not represented in proceedings. And then in the Indigenous judgments context, the fact that mainstream justice processes are premised in settler colonial societies, are premised on the dispossession of Indigenous people. And so it's very different for an Indigenous judge to sort of operate within that court system, which is a denial of their own sovereignty. And similarly with the wild law judgments, the fact that mainstream judicial systems are inevitably anthropocentric and therefore, find it very difficult to be inclusive of the broader environment. So that sort of led into thinking about, more comprehensive, more holistic alternative justice processes. And the examples that exist here, sort of problem-solving courts, which often rely on principles of therapeutic jurisprudence, so the notions that the justice system should not just be involved in, applying law to facts and reaching dispassionate outcomes, but providing healing and certainly not increasing trauma or increasing harm to people, but also providing some kind of psychological healing or improvement in their well-being. And also restorative justice principles, which are, about not just punishing, but reintegrating offenders into society through their ability to address, engage with and make amends to the people that they have harmed. And there are a whole lot of different kinds of problem-solving courts that now exist, some of them based on the characteristics of the offender, so things like drug courts, mental health courts, homeless courts, veterans treatment courts, Indigenous sentencing courts, which incorporate Indigenous elders and Indigenous communities in decision-making around sentencing. Some of the courts are based on particular problem types, so domestic violence, family violence courts, community courts, re-entry courts, which are courts that deal with people who are transitioning from prison back into society. Most of these alternative justice processes, which are, aim to be much more holistic, have been in the sort of lower level criminal justice and family law contexts. What they have in common is that, so they're focused, they're, unlike the mainstream justice process, they're actually usually focused and built around the position of the marginalised and the disadvantaged, people who are substance addicted or, victims of domestic violence and so on. They usually involve a multidisciplinary court team, so it's not just, the judge. The judge it'll be accompanied by social workers or support workers for both parties or for defendants in criminal proceedings. And might also involve some kind of connection with community services. So it's making sure that people are getting the assistance they need to stop offending, rather than having the revolving door of the sort of the problems that they experience leading them into repeat offending. And so the idea is to sort of change the in a criminal context, change the defendant's circumstances so that they will no longer be the subjects of criminal justice. And so that also makes a different role for the judge, who is not just being an adjudicator, but also sometimes operating as a coach and a mentor, sort of helping the defendant through the sort of services, the program that they're engaged in to stop drug using, or to, for domestic violence perpetrators to, stop relying on violence, to sort of get them to that point whereby they can then be, exited from the court system. So there is the sort of possibility for change in the circumstances of the person who is the subject of the problem-solving courts, so that their life circumstances will change, and so it's taking a much more holistic approach. On the other hand, there have been, some quite strong critiques of this approach, that it can be very moralizing, normalizing, often coercive. The way, if the idea is in a drug court to stop you from engaging in substance abuse in order to stop criminal offending, then that can be quite a coercive process, despite the fact that people are supposed to consent to participate in the process. That can be a very compromised consent if it's like, you can get all of these services and this assistance if you plead guilty and agree to participate in a program, but if not, you're going to jail. So there's concerns about the freedom of consent. Certainly issues in many cases with the resourcing that's provided, because they take up, they're much more resource intensive, with how models are implemented, with people dropping out of the programs, and then having a worse outcome. Not a lot of, often they haven't been well evaluated. And when they have been evaluated, the outcomes don't always match the aspirations. So this is sort of not really clear, validated models that, you know, will produce determinate results. And of course, they still don't address the kind of structural problems why people, if they don't address the sort of structural societal discrimination, structural gender discrimination, structural poverty. It's still very much coming down to, you know, working on the individual and the individual being expected to change. And then there's also concerns both that they can be under-inclusive in terms of restrictive eligibility rules. So, for example, one of the things that evaluation studies have found with drug courts in the United States is that the vast majority of participants in the drug court programs are white, whereas the vast majority of, you know, drug-related offences are committed by Black people. But the way that, because they often exclude crimes of violence, so that has a racial effect and means that the programs are less accessible to on a sort of racial basis. They also are over-inclusive of women and under-inclusive of men. But by the same token, also perhaps in some of the youth justice contexts and the restorative justice contexts, there's a concern that they're over-inclusive. So you have a net widening effect. People are brought into programs when in fact the kind of sentence that they might receive if they weren't brought into the program would be quite light or might be diversionary anyway. And so you know, both of those critiques about being under and over-inclusive can be made. So these alternative justice processes are sort of much set out to be more inclusive in much more holistic ways, and to think about targeting the marginalised and the disadvantaged, but these critiques are made of them, and there's certainly probably room for improvements in some of these models to address those critiques. And then the other sort of area of alternative justice processes are often of what I've called non-state alternative tribunals. So these are a sort of ad hoc tribunals, courts that have been set up within civil society, so usually made up of academics and lawyers. They often hear from real witnesses and receive real evidence, but try to find ways of providing remedies that that overcome the inadequacies of both national and international legal regimes to address some of the sort of far-reaching forms of collective harm, and to address some of those sort of structural oppressions and power relations. And so things like the Women's Court for former Yugoslavia and the International Rights of Nature Tribunal, the Women's International War Crimes Tribunal, sort of really developed very innovative concepts and procedures to overcome some of the sort of limitations of mainstream justice systems in this area. So, I mean, they're sort of great models and great examples, but of course they are all fictional in a sense, in that they have no authority, and so they're showing how things could be done, but like the feminist judgment and critical judgment projects, not actually being themselves the thing part of the mainstream justice system. So where might we be going with all of these inclusive judging initiatives in the future? So clearly what we've got at the moment is, you know, a series, certainly with the problem-solving courts, a series of ad hoc disconnected initiatives, and, you know, what we're not seeing yet, and, you know, may see in the future, is the sort of mainstreaming of these approaches. The closest that we've come to that at the moment is an initiative in New Zealand, which is called Te Ao Marama, which is attempting to mainstream problem-solving therapeutic pluralistic approaches into the entire district court system in New Zealand, to incorporate Maori concepts and sort of culturally appropriate ways of responding to Maori offenders, but it applies to everyone. But that's only just getting off the ground, so we don't really sort of have much in the way of results from that yet. Certainly at the level of the individual judge, you know, I've talked about the fact that being a different judge and judging differently can take individual courage. And in order to change that, we would need certainly a more diverse judiciary, but also perhaps some normative encouragement to be more inclusive, which we don't currently see. And at present, at most, probably what we have is these equal treatment bench books, which have been introduced in a number of jurisdictions, which kind of explain outsider court users to traditional judges. So it's a kind of an assumption that here are all of these outsider groups that the the elderly white male judges need to know about. So there's a book that sort of explains religion and race and gender and disability and various other things for the mainstream court to inform itself about the differences of the people coming before it. Whereas what we could move to is something that perhaps different judicial selection criteria that would value diversity in the judiciary, that would value, that would look not just necessarily at the qualifications of the individual judge, but at what is needed for the institution as a whole, and try to construct an institution, a judicial institution that incorporates all of these differences rather than leaving them outside to be, learnt about, to be known about by the judges themselves. But at the moment, we're not really seeing any of these sort of more mainstreaming initiatives, but so they're places that we could go, but that is very much, a kind of utopian aspiration for the future. Okay, I'll stop there. Thank you very much.
Well, thank you so much, Rosemary. That has been, I think, a fantastic presentation, very comprehensive. You have touched on many of the issues that we have been discussing in our course, and I think a very broad range of topics. And I think also you have given us much food for thought as to how progress or transformation of the judiciary and the judicial systems, the way judiciary and decision-making bodies are organized. And I'm sure that much of this can be, many of these findings and many of these intuitions can also be transplanted to other institutions that are engaged in decision-making, not just the judiciary as such, as a power, if you like,
yeah.
It's a special position. So I think you have opened a very broad panorama and given us many interesting avenues for exploration, and also given us some hints as to how some of the research could carry on, could be how to do research about these topics, which is always an important concern. At this stage, I think what I would like to do is to open the floor to questions and comments. So the floor is open. Please raise your hand, and whoever would like to intervene, raise your hand and then unmute yourselves and ask your question if you would like to. In the meantime, as a chair, I think it is my duty to have some question while people are trying to think over what they would like to ask. And my question would then be, what is the worst scenario of all? Is it one where judging and judges are not inclusive at all? So if you like, the more traditional view that we had about judging, in theory, impartial, with covered eyes, not knowing who is there pleading, who are the parties, what are the particular characteristics, speaking as a machine almost? Or would it be even worse, perhaps, to have judges that are inclusive for some and exclusive for others, which is sometimes the impression that, according to some researches, some parties or victims and other participants in the process get from the impression that they get from the experience in court.
Yeah, no, that's a really good question. So I guess my concern is not with, judges bringing their own, particular perspectives to bear on judging, but the inclusion of, and it's very specifically the inclusion of the traditionally marginalised and unrepresented. So so I'm trying not to open it up to right-wing, racist, white supremacist, conservative things, because they're already well represented.
Yeah.
It's about including the previously excluded, and I think that's the angle that I'm concerned about. So yeah, I mean, I agree. It's not a good thing when sort of we just say we open it up for partiality. That is not something that I'm arguing or would seek to argue, but it's opening it up for previously excluded perspectives and experiences, which is my central concern.
Good. Any questions in the meantime? Some more reactions? I still can't see any hand raised. Yes, I think Sabine would like to intervene as well. Go ahead, Sabine.
Yes, I think in the part you presented on techniques of inclusive judging, I was reminded of thinking about legal decisions in specific, that there, for many, perhaps there seems to be a right or wrong in that. And I think you even suggested that intuitively one might have already the decision and then has to rationalize it in terms of legal arguments. No, so in that context, I was wondering whether inclusive judging, which includes counteracting biases and structural disadvantages and so on, whether it is premised on that one believes in law's indeterminacy, which is a bit like a legal realist argument that there is always more than one way to decide, or one decision which can be justified by legal arguments. So there's not just one solution, but there's like contingency, maybe several possible solutions. And if one believes in that, then it seems to be easier also to really think about the framing, think about the construction of facts, as you said, thinking about what other pathways to a decisions might yield, no? And just trying on these things. So what do you think about that, like this premise of a belief in law's indeterminacy as facilitating inclusive judging?
Yeah, I mean, I think it certainly facilitates it, and it's the basis on which a lot of the sort of theoretical work has been done. But I don't think you have to. I don't think you have to believe in indeterminacy in order to understand that there isn't necessarily one right answer. So the notion that there is one right answer, I think, is the fiction. I mean, that's the impression that law likes to portray, and I mean, that's part of the law's legitimacy, and part of the sort of power of law is to present its decisions as inevitable, and that there is only one possible right answer. And then often, things are written to make it clear that there's only one right answer, and students are taught that there's only one right answer, and that what they have to learn is the techniques for getting to the right answer. But I think any kind of reasonably sophisticated form of legal analysis begins to see that there's not always just one right answer. I mean, in any system where you have the possibility for dissent, then you will have cases where judges are disagreeing on what is the right answer. And so, the notion that there will only ever be one right answer, I mean, in many cases, there will just be one right answer. I completely accept that. But there are, still substantial numbers of cases where there are just going to be different ways of seeing it, different possibilities. And I don't think you need to actually sort of embrace the whole postmodern radical indeterminacy theory in order to acknowledge that, but simply you know, look at the ways in which dissent works in, you know, very traditional legal systems often, or in which even concurring judgments. So when you see somebody who says, where judges say, yes, I agree with this answer, but I would reason, you know, my reasons for getting there are different. And that's also been the case in a lot of the feminist judgments. So they say, yeah, we agree with the answer, but here's some different reasoning that is more inclusive, that takes into account, that tells a story about, that acknowledges, you know, the life experiences of this particular group of people, rather than marginalising. So in a sense, it's sort of law acknowledging the existence of people and recognising, providing recognition, even if the outcome is exactly the same.
Very good. Yes.
Yeah.